Now we have to move towards the next topic, that is the comparison of the constitutions. Now we adopted parliamentary democracy based on the British model, but how does our model differ from that model? So we have to see how Indian model is different from the British model. As regards to the legislation, the British Parliament is supreme or sovereign, but in India, power of the Parliament to legislate is limited. This is correct. In India, the Parliament is supreme but not sovereign. We have the limitations in the form of the written constitution. There are generally 4 limitations with respect to the sovereignty of the Parliament. First, we have a written constitution. Second, we have federal structure, that the Parliament generally cannot legislate on the state level. I am using the word generally. Parliament can, but only on special circumstances. So we have the federal structure. We also have fundamental rights. It means as per Article 13, the legislature or any law cannot violate the fundamental rights. And fourth, we have the independent judiciary. Independent judiciary. Okay? Now just understand, sometimes a question comes that veto powers of the president restrict the sovereignty of Parliament. True or false? So it is a false statement, because veto powers are with the president. President himself or herself is the part of the Parliament. So Parliament, when we talk about, we are talking about the President, Lok Sabha and Rajya Sabha. So veto powers are not restricting the sovereignty of the Parliament, though it is a power that is given to the President. So answer, first statement is correct. In India, matters related to the constitutionality of the amendment of an act of the Parliament are referred to the Constitution bench by Supreme Court. Yes, it is also correct. There is a Supreme Court bench of minimum 5 judges. Whenever there is a minimum 5 judges bench, then it is called as a constitution bench. So answer to this question will be C, both correct. Okay, so answer will be both correct. Now next question. Preamble, every year there are one question or generally one question from preamble, and the question will be very simple, right? Mostly factual question comes from the preamble. What was the exact constitutional status on 26 January 1950? It means they are asking what was mentioned in the original preamble. A democratic republic? No. A sovereign democratic republic? Yes. Sovereign secular? No. This secular word was added through 42nd Constitution Amendment Act 1976. A sovereign socialist secular? No. Secular and socialist, they both were added through 42nd Constitutional Amendment Act 1976. It means the answer is B, sovereign democratic republic. Then the preamble to the Constitution of India is a part of the Constitution but has no legal effect. Not a part of the Constitution has no legal effect either. Not a part, so it is the wrong. It is a part of the Constitution. A part of the Constitution and has the same legal effect as any other part. A part of the Constitution but has no legal effect independently of other part. The answer will be D. As per the Keshwanand Bharati case, the preamble is a part of the Constitution. Preamble, though, has no legal effect and it is also not having any restriction. It means it has no legal effect independently of other parts. If it is in application of some of the parts, for example DPSPs, they are having a legal effect for the socialistic ideas, for the ideas of fundamental rights. We have implementation of the liberty that is mentioned in the preamble. So independently it does not have a legal effect, but combined it may be used as a source, but maybe it is not a source. Be very clear, not a source, but independently not a legal effect, but combined maybe. So answer will be D. Which of the following objectives is not embodied in the preamble to the Constitution of India? Okay, so liberty of thought, yes it is there. Economic liberty, no. Economic justice it mentions. It does not mention economic liberty, it mentions about the socio-economic and political justice. Liberty of expression, yes. Liberty of belief, yes. So answer will be B, because it mentions about 5 types of liberty: liberty of thought, expression, belief, faith, or worship. It mentions about 3 types of justice: economic, social, and political. No economic liberty. So answer will be B. The mind of the makers of the constitution is reflected in, very direct question, it is reflected in the preamble. So the mind of the makers is reflected in the preamble. Okay. This statement is given by the Honorable Supreme Court in the Berubari Union case. In the Berubari Union case 1960, they have provided this judgment that preamble reflects the mind of the makers of the constitution. Okay. Now next question, let us see. Economic justice as one of the objective of the Indian constitution has been provided in preamble, yes, it is there. And fundamental rights, let us see, read the other statements. The preamble and the DPSPs, yes, it looks correct. Let's see other statement. Fundamental rights and DPSPs, no. In the preamble, it is specifically mentioned, none of the word. It is also wrong. So it is the B. It is mentioned in the preamble and the directive principles of state policy. Now, with reference to the scheduled areas in India, consider the following statement. It's the latest question, 2023. Within a state, the notification of an area as scheduled area takes place through an order of the president. Yes, it is true. As per the article 244 of the Honorable Constitution, it is the president that can give the notification. The largest administrative unit forming the scheduled area is the district, and the lowest of the cluster of villages is the block. Yes, it is also correct. Right. The chief minister of the concerned states are required to submit annual report to the Union Home Ministry on the administration of the scheduled areas. It is not the chief minister, it is the governor, because governor is the executive head of a state. So governor as an executive head of the state gives the report. So in this 2 are correct. This year UPSC has asked question in this form, 1 correct, 2 correct, 3 correct. So in this only 2 are correct. So A and B are correct. Now next question, if a particular area is brought under the 5th schedule of the constitution, which of the following statement best reflect the consequences? Now this will prevent the transfer of land of tribal people to the non-tribal people. It seems correct. But as I repeat again and again, we will not mark the answer until and unless we read all the other options. This will create a local self-governing body in that area. May be correct. If we are talking about PESA, PESA means Panchayat Extension in Scheduled Areas. This would convert an area into union territory. No. The state having such areas are declared a special category state. No. So the main purpose of 5th schedule is to protect the interest of the tribals. Would create a local self-governing body, that is not for the 5th schedule. That may be included as a part of the 11th and 12th schedule of the constitution. So answer will be A, the area brought under the 5th schedule of the constitution. Then next, the 9th schedule was introduced in the Constitution of India during the Prime Ministership of 9th schedule. 9th schedule, it also added Article 31B, added through first Constitutional Amendment Act 1951. And in 1951, who was the Prime Minister of India? Pandit Jawaharlal Nehru. So answer is A, Pandit Nehru. C, A. Then under which schedule of the constitution India can transfer tribal land to private parties for mining be declared null and void. It means which schedule protects the land of the tribal community? 3rd schedule? No. 5th schedule? Yes. 9th schedule? No. 12th schedule? No. In order to remember this, there is an acronym that you may remember: Years of Old PM. Through this you can identify the 12 schedules of the constitution. It is first schedule that talks about the territory, union and its territory. Second schedule talks about the emoluments, salary. Third, it talks about the oath and affirmations. So third is oath and affirmation, not the land for the tribals. Fourth is the Rajya Sabha seats. Fifth is for the scheduled areas. It means fifth schedule is the answer B. Sixth is the other scheduled areas. F is for the federal structure, seventh schedule, that gives the list, union list, state list and concurrent list. Then eighth is for the official languages. We have 22 scheduled languages, so it is in the 8th schedule. Ninth schedule is for land reforms. It does not declare null and void, rather it declares that if a land reform is to be brought and it is put under the 9th schedule, even if it is violating the fundamental rights, it will be considered to be valid. So it is not declaring null and void. Then 10 is for anti-defection. Then 11 is for panchayat and 12 is for municipalities. So these schedules provides, or these 12 schedules, they can be remembered through the tiers of old PM. This can be the acronym. Next question. The Parliament of India can place a particular law in the 9th schedule of the Constitution of India. Yes, it is correct. Parliament can put a law. The validity of a law placed in the 9th schedule cannot be examined by any court and no judgment can be made on it. This is wrong. Second is wrong, because as per the IR Colo case, 9th schedule is not out of judicial review. Is not out of judicial review. It means there can be a judicial review. Okay, there can be a judicial review. Clear? So the answer to this statement is A. Then sixth question. The provision of 5th schedule and 6th schedule and Constitution of India are made in order to protect the interests of scheduled tribes. Yes. Determine the boundaries between states. No. Determine the powers, authority and responsibility of panchayat. No. Protect the interest of all the border states. No. So answer will be A, protecting the interest of the scheduled tribes. Then 7th question, which of the following schedules of the Constitution of India contains the provisions of anti-defection? We just saw that anti-defection is D, 10th schedule. So the answer to this is D, 10th schedule. Okay. So now you are in a position not only to tell which of the following is the anti-defection, you can tell all the answers, that it is the emoluments, it is for the scheduled areas and it is for the official languages. So answer will be D. Clear? So we have discussed some of the questions today. Next, other questions that will be from the topics of fundamental rights, DPSPs and fundamental duties, I will be discussing in the next video lecture. Thank you very much and continue preparing. If you have any doubts, you can post your doubts in the comment section also, so that we can get your doubts addressed, and in a case of any query also you can comment below the video. Thank you very much.